Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, I'm John Roberti. Welcome to our Curious Amalgam, the podcast from the American Bar Association section of Antitrust Law. Today's topic is, who does antitrust work for? An exploration of labor antitrust. Labor issues in antitrust have always been with us, going way, way back. In fact, the role between labor and antitrust was an issue early on as exemptions were created and courts tried to deal with them. What has come to the fore recently, starting at maybe at the turn of the century, but really in the last 10 decades, has been an increased focus on the anti-competitive behavior in labor markets and how do you identify them? How do you deal with them? How do you remedy them? Labor markets are not necessarily the same thing as product markets, although many of the concepts do switch over. Today, we have one of the leading experts on labor antitrust with us to try to help us to understand those distinctions. My host today is Sergei Zaslavsky. Hi, Sergei.
Hi, John.
Sergei, what are we doing today?
So we're going to talk about labor antitrust. Antitrust enforcement is usually focused on the effect of conduct on consumers, but most of us are both consumers and workers. So an increasingly important part of antitrust is labor antitrust, which focuses on the competitive effects that impact workers rather than consumers.
And why is this important?
Well, a couple of reasons. One, as you said, it's been a more prominent area in the past 10 years or so, especially given DOJ statements that started with the HR guidelines. They came out a few years ago, making clear that naked or no poach wage fixing agreements are per se illegal and could even be subject to criminal liability. I think there's also a broader point, and perhaps the reason that labor antitrust been getting more attention. Labor antitrust plays a really important role in the ongoing debate about the state of antitrust law. Some commentators point to macroeconomic trends related to labor they see as worrisome, such as increasing inequality or wage stagnation. And they point to antitrust issues as either contributing to these problems, or at least they think antitrust policy can be a potential solution to these problems.
Okay. Great stuff, Sergei. Keep going.
Okay. Some commentators also say that antitrust has been too focused on consumer welfare at the expense of other priorities, such as workers. And I think because there's been such a healthy debate about these subjects, certainly with a lot of people on either side, labor antitrust has really come to the fore as a prominent topic.
All right. Well, obviously, I'm very excited to bring in our guest. Who is our guest today, Sergei?
So we are very lucky to welcome Professor Hiba Hafiz to the program. Hiba has experience with organized labor. She has experience practicing antitrust. So she is uniquely qualified to really provide some expert commentary on the intersection of these two areas of law. She currently teaches at Boston College Law School, and we're very, very lucky to have her with us today.
Well, okay, let's bring her in. Professor Hafiz, welcome to the program.
Thank you so much for having me. I'm very honored to be here. I love your podcast. I'm a big fan.
Hi, Hiba. We're very glad you could join us today. So John and I talked a little about labor antitrust, but we're just amateurs, so we want to hear from the expert here. Could you tell our listeners, unfamiliar with the term, what does labor antitrust really mean?
So labor antitrust is just using the antitrust laws to target employers' anti-competitive agreements or their anti-competitive conduct in labor markets specifically. And you can do this under any provision of the antitrust laws. You can use Section 1 to target employers' wage fixing or no poaching or even non-compete agreements. You can challenge employer conduct under Section 2 for monopsony or attempted or conspiracy to monopsonize labor markets. Or you can look at labor market effects of mergers under Section 7. So really trying to incorporate labor market effects into merger reviews that the agencies are conducting, but also, potentially using Section 7 ex post to challenge the effects of mergers that might have impacted workers.
Oh, it's interesting. It sounds like it pretty much pervades all of the antitrust. We've got Section 1, Section 2, Section 7. As far as U.S. antitrust law, that covers the basis pretty much. So I'm curious, how did you come to focus on this particular area of antitrust? Can you tell us a little bit about your story and what led you to focus on labor antitrust?
So my personal story is that, I came into workers' rights. I'm originally actually from Saudi Arabia, so I was interested in migrant workers' rights from very early on, and then also interested in union organizing when I moved to the States, and just thinking about really creative ways of using the law to protect workers, whether that's under human rights law or under labor law or other work law statutes. And what I found as I was, involved in the union movement when I was a graduate student was that there are really limited protections for workers in this country. I was studying comparative literature, so I wasn't really aware of all of the legal components of the regulatory scheme, but I was aware that there were very limited protections, and so I became interested in thinking through ways you could use other private law mechanisms or commercial law mechanisms to help workers. And I was lucky enough when I went to law school to study antitrust law with Scott Hemphill, who actually assigned a labor antitrust case in our antitrust class. It was the nurse wages case, which is a Section 1 wage fixing case. And so for me, it totally normalized antitrust as a tool to prosecute or litigate harm to sellers and not just harm to buyers. And I was interested in figuring out ways of using antitrust to more broadly benefit workers. And so I was lucky enough to work at Cohen Milstein, which is litigating some of the leading labor antitrust cases on the plaintiff side. And I was able to practice labor antitrust both under Section 1 and Section 2.
That's very interesting. Sounds like you're pretty lucky. You got interested in something before law school and went to law school and actually found it relevant to what you were interested in. So
it was relevant. Yes.
So it seems there's been more focus on labor antitrust in the past few years. Is that just, a misperception, or is it accurate that it's really kind of come to the fore in the past 5 to 10 years?
I would say that, for folks who work in sports law or sports antitrust, labor antitrust is not a new thing, right? Antitrust law has been intertwined with sports law issues, reserve clauses, free agency issues for decades, and has been litigated up through to the Supreme Court, obviously starting Flood versus Kuhn and earlier. So in the 60s and 70s, there were a lot of tensions between kind of worker protections in the sports context, using antitrust law versus using labor law to help workers elevate their wages in the context of sports. Outside of sports, it's been really just a spattering. In the 90s and 2000s, there's some lead cases like Todd versus Exxon, Eichhorn versus AT&T in 2001, and a spattering of other cases where labor antitrust issues were addressed along with other claims. In Todd versus Exxon, it was actually one of the first information sharing cases brought by non-union managerial, professional, and technical employees that really kind of brought to the fore and had the Second Circuit validate a theory of suing employers for sharing information on wages under Section 1. But really, as you said in the introduction, labor antitrust has really started to soar in the past 10 years. And I think it's for a bunch of reasons. As you mentioned, there are political movements to expand antitrust and to think through how antitrust can work to alleviate distributive harms or inequality. But there's also been changes within the economic scholarship and economic literature that have been really substantial. I think before the past 10 years, there was this kind of presumption in economic theory that labor markets were in fact competitive. There's been a lot of both theoretical but really substantial empirical research by economists, labor economists, and industrial organization economists into how, in fact, labor markets have become increasingly concentrated, how pervasive employer buyer power is over workers, and how labor market failures that occur naturally in labor markets accrue to employer buyer power. And these changes within the economic literature were happening at the same time that there were substantial criticisms of the labor law and employment law being really broken for workers. And so antitrust law became a way to really think through innovative regulatory solutions to pervasive employer buyer power.
And has this new economic thinking made its way into the courts yet, or into agency policy, or is it still mostly academic discussion, still kind of percolating and waiting to make its way down to the actual enforcement level?
Yeah, no, I think it has been institutionalized significantly in the agencies and within the White House, but not so much in the courts. So during the Obama administration, Obama appointed as chair to the Council of Economic Advisors Alan Krueger and Jason Furman, both of whom were interested in employer monopsony power and were drafting really important white papers on monopsony and its impacts on the economy, both the microeconomic impacts and inefficiencies that result in labor markets, but in the case of Furman, also macroeconomic effects of labor market concentration and monopsony power. So it really did inform the Obama administration's policy from kind of the top down. Also informed, political appointees that were chosen to run various divisions of the Labor Department and the antitrust agencies. And the agencies themselves were recognizing the importance of looking at labor market effects. As you cited that 2016 antitrust guidance for human resource professionals that was issued by the DOJ and the FTC. But there also been, in the case of plaintiff side litigation, economic experts that have been key for thinking about and theorizing employer monopsony power that have been filing expert reports in antitrust litigation as well to help inform the courts of why, in fact, monopsony is pervasive in labor markets and in particular cases that they are doing expert work for, demonstrative in those cases. So people like Orly Ashenfelter, Alan Manning, Roger Knoll, kind of these really important and famous economists in this area have also been, there to kind of help the courts understand how they should understand these cases as working. The courts have been much less consistent in how they're responding to this new information, and we can talk about that. But I do think that there's been a significant level of expertise that's been brought to these issues within the government.
Tell us about the inconsistency in the courts, and what, if any, kind of have been the roadblocks or the doctrinal impediments to accepting this new thinking on labor antitrust.
There have been lots of challenges. So courts have been really confused about how to handle labor antitrust cases. So I would say that the main tension that has emerged in the courts is courts' confusion about what types of harms labor antitrust plaintiffs are required to demonstrate in order to vindicate their claims, right? Whether or not showing harm in the labor market is sufficient to establish an antitrust claim, or whether they are required to also show downstream harm to consumers. And courts have been very confused about how to evaluate defendants' arguments about consumer welfare benefits of certain types of restraints or certain types of conduct in evaluating the harms in the labor market. And for the most part, workers haven't, this is such a new area. And so, a lot of these cases, most of these cases are still undecided. They've passed the motion to dismiss case in some cases, but, they're still either like in the middle of litigation or have settled. And so there's still very limited law, but the law that is out there has been really inconsistent on these questions.
Help me to understand. I just want to follow up on what you said because it's very interesting. I think one of the hard questions that have come before the court, and the section has explored these issues in the spring meeting and elsewhere, come when there's a labor restraint going along next to something else. The classic example is a franchise agreement, which has some sort of labor restraint in it. But even going back to the early cases where you had the high tech workers, there were sort of joint ventures going on in the background. How does that all fit together?
So there's. I think it does depend on the procedural posture of the case and the types of claims that are being brought in any given case. I think the great example that you point to is the no poaching agreements that are included in vertical agreements and franchising agreements, right? So just for listeners who don't know about these cases, these are basically the McDonald's and Taco Bell's and Jimmy John's of the world, franchisors who in their franchising agreements with their franchisees include no poaching provisions that basically say you as a McDonald's franchisee can not only not hire another McDonald's franchisee's employees, but you can't solicit their employment. You can't try to attempt to hire them. You can't, like share information, things like this about, workers that could, that basically restricts worker movement between franchisees. And so these cases have been litigated, so there have been early cases that have been brought. And the challenge that the court has faced in these kinds of contexts is, okay, we're looking at an alleged labor market harm. Where we're dealing with no poaching agreements, which in the horizontal context, we understand to be per se unlawful. In the vertical context, we understand them to be, we evaluate them under the rule of reason, just like we would any other vertical agreement. Under the rule of reason, right, you're depending on the circuit, right, you're really looking both at the anti-competitive effects in the given market, but you're also looking at the professed pro-competitive benefits of the agreements that the defendants are asserting. Here, the defendants have been really inconsistent on and kind of just thrown everything at the wall in terms of the potential pro-competitive benefits, right? So they use the standard labor market benefits of, these no poaching agreements encourage training, they encourage franchisee investment in making sure that, all of the time and money and resources they spend in investing in workers doesn't get wasted or result in free riding by other franchisees. But then they've also made a bunch of arguments that, we only have these provisions in these franchising agreements because we're really trying to ensure that consumers get the best possible product. Right. And we think that in tandem with all of these other provisions in our franchising agreements that are there to ensure brand quality and brand uniformity within the franchise, these are necessary to have the kinds of consumer benefits that you get from franchising. And courts are really confused about how to deal with those consumer benefits. I think it's understandable because the case law has been very confused on these questions. But I think what's tripped courts up for the most part is this false intuition that lower wages lead to lower prices. Which, as a matter of economic theory, is not accurate, and that labor antitrust plaintiffs, again, have to show downstream harm to consumers in order to vindicate their claims. In fact, when you look at the monopsony cases that do exist, and if you look at the horizontal merger guidelines and Section 7 and so on, there's all sorts of evidence within the antitrust laws that you're not supposed to do cross-market balancing when you're evaluating the effects of a particular restraint. Right? You're looking at the effects of the restraint in one market, and the benefits, the pro-competitive benefits, have to be in the same market. but courts have ignored that requirement in many cases and have been very confused in part because of the dominance of the consumer welfare standard.
And I think Professor, you've hit that right on the nose. Courts, I think it's been a real struggle. I mean, you have some litigants coming in and saying these agreements are going to be per se unlawful. The Washington Attorney General has taken that view, and they've gotten by the way, they've gotten a bunch of consents around that. The Department of Justice, I think, has come in and said, well, you have to look at this under the rule of reason. And that was recent. That's not the Obama administration. That was in the Trump administration. And again, I think courts are really, really struggling with that. I want to ask you a question, though, and I want to draw on your labor organizing, perhaps bias, when I ask this question.
Okay.
Does it matter? Does it matter if the restraint is on high wage workers as opposed to low wage workers? Should antitrust care about that?
I mean, on its face, it shouldn't care about it, right? We don't ordinarily, in other contexts, when we're looking at product markets, evaluate antitrust harm any differently if it's happening in, say, a luxury good or a essential good market. That might impact enforcement strategies and priorities for the agencies and for, potentially private plaintiffs in, doing impact litigation. But as a matter of law, right, there isn't any reason to be distinguishing between what types of, as a matter of the requirements of the elements of a claim or standing issues or other threshold issues. There shouldn't be any distinction.
And again, I'm going to import a product market concept. Does that go to buyer power? In other words, if you're a higher wage worker, do you have more ability to push back against a restraint than, say, a lower wage worker?
Yeah. So, I mean, it's a fascinating question. Ordinarily in antitrust, what you would look at, if you're looking at it, okay, so we're in the per se unlawful territory. Let's just say we're in Section 1. These are horizontal agreements. Market power doesn't matter. So we're only talking about the limited set of cases that are maybe Section 1 vertical agreements that are not hub and spoke conspiracies, and Section 2, and then potentially in the context of, merger reviews. And in those contexts, when you're evaluating, the defendant's conduct, you're looking at the defendant's market power, right? You're looking at the defendant's ability to, in the case of, because we're talking about monopsony here, to reduce inputs. Or artificially suppress, in the case of workers, artificially suppress workers' wages if you're focusing on a wage effect. And in those settings, you're evaluating their market power in the relevant labor market, right? And that analysis that you would do in a labor case would be very similar to the analysis that you would do in a product market case. It wouldn't matter how highly priced the good is. It just matters if they have market power in that market. So yeah, you could still have a monopolist of luxury goods, right? Just like you could have a monopsonist in really high paid mixed martial arts fighters.
Hiba, I kind of have a big open-ended question for you. You mentioned that one of the things that confuses courts is how to deal with situations where there's some harm to workers, but there are certain benefits to consumers. Obviously, there's been a lot of discussion about the consumer welfare standard and whether that's really the right standard going forward. Do you think we can have effective labor antitrust enforcement within the consumer welfare standard, or do we need reform there, in your view?
So yeah, I think within the literature, what folks have talked about in the context of labor antitrust issues, in part, is instead of framing the relevant welfare standard as a consumer welfare standard, framing it in terms of a trading partner welfare standard. And this is something, in fact, that the DOJ and FTC have hinted at and written about in guidances. And it's also something that scholars have written about as a better way of understanding the types of harms that are occurring in labor markets. when we're talking about the consumer welfare standard, the way that courts have dealt with evaluating labor antitrust claims in a bunch of cases has been to think of the worker plaintiffs as the quote unquote consumers, right? And to evaluate harms of particular restraints or conduct on their welfare as evaluated through, and say, an artificially suppressed wage or, qualitative harms in their working conditions or something like that. But as they're doing that, they're also, because defendants are raising a number of defenses to these kinds of claims, they're also focusing on what they would, I guess, technically understand as a separate set of consumers. And those are the downstream or end user consumers of the employer's products. Right. And so if you're framing the issue that way, right, that you have two sets of consumers, it starts to become confusing about, well, I'm supposed to be, as a court, applying a consumer welfare standard, so maybe I should be balancing the effects on these two sets of consumers. When in fact, right, that's not what you would ordinarily do necessarily in a product market where you're challenging the anti-competitive agreement or conduct in that relevant product market. You're not looking at another set of consumers that could be harmed. In fact, this is what Philadelphia National Bank establishes. And so really, I think the problem is that courts are confused and tripped up because they understand the welfare standard to be a quote unquote consumer welfare standard. Other courts haven't been confused and have looked at labor antitrust cases and looked at alleged harms in labor markets and found, in fact, that those constitute unlawful restraints without looking at downstream effects. But I think part of the confusion comes from framing it as a quote unquote consumer welfare standard rather than, say, a trading partner welfare standard.
Well, it sounds like it's a fascinating area of law and somewhere where there are a lot of current ongoing developments still very much in flux. Could you just quickly summarize for us what are the really big developments going on right now? Where do you see this going?
So I think the biggest developments will be in potentially down the road, coming up with better government guidance on how to understand and litigate these types of claims. And particularly this is important in the context of merger review, because both the DOJ and the FTC have committed to reviewing the labor market effects of mergers. They haven't given a lot of guidance on how they intend to do that. And so I think there's a lot of room for the agencies to clarify to merging parties, regulated parties, but also to unions and labor advocates on how they plan to assess labor market effects in mergers going forward, and potentially how they plan to evaluate harms in labor markets that might result from mergers to the extent that there may be reduced harms in consumer in product markets, right? Or there might be real efficiencies that are created in product markets. So I think that's going to be a really important area for the agencies to flesh out and clarify. And I think with respect to developments in other areas of law, Section 1 and Section 2, top line priorities have been these no poaching agreements. But then I think very, very near and queued up to that is going to be antitrust review of the use and pervasive use of non-compete agreements, and particularly in the context of low-wage work, where employers are including non-compete agreements in employment contracts with low-wage workers. And that has been the subject of a lot of academic and also government regulatory interest. And I think there's a lot of room to regulate in that area that will be important going forward. And then, in terms of Section 1 and Section 2, really, I think that what's going to matter is figuring out how we're going to apply the rule of reason to labor antitrust cases in ways that really focus the court's attention on requiring defendants to establish pro-competitive benefits in labor markets rather than it showing potential pro-competitive benefits downstream. Again, as a matter of economic theory, right, when you reduce the inputs, you also are reducing outputs, right? And in markets where you have some market power downstream, that results in higher prices to consumers. That's in most circumstances how monopsony works, and that should be the presumption that the courts are applying when they're evaluating labor antitrust claims.
Let me ask you one last question before we shift gears. There has been, I mentioned at the top, there's been an increased awareness in the past, let's say even 10 years, maybe even a little bit less. And it's not just the no-poach agreements. I think we sort of all point to that, but it's not just that. There's been scholarship that has talked about labor remedies, some very good articles being written. There are new cases being brought. There's new guidance coming in. Why? What was this? Is this a new thing, or did we just figure it out? And what made us figure this all out? What happened?
Oh my goodness. I think it's a complicated story of things converging. On the one hand, you have less and less labor market regulation, right? The labor law is broken. Union density has plummeted. You have increasing empirical studies into pervasive wage theft, and just massive inequality. And that literature has really focused attention on ways that we need to be regulating labor markets that could overcome not just market failures that persist in labor markets, right? Information asymmetry, search costs, right? All sorts of market failures that pervade labor markets. But also on top of those labor market failures, right, you have employers engaging in a whole range of conduct that just is not being regulated, right? And to the extent that there are limited protections under work law itself hasn't been incorporating the kind of social scientific expertise that the antitrust agencies have brought to market regulation. So, for example, most people don't know this, but the National Labor Relations Board is actually banned from hiring economists. So when the National Labor Relations Board is making decisions about who counts as an employer or whether or not, workers should be able to engage in certain types of conduct that's protected activity, they're never looking at whether or not their, various upstream employers might have wage setting power or maybe, have market power over them in ways that they can't engage with because they're not allowed under the law to collectively bargain with upstream employers based on standards that don't track economic realities. And so because of that, the failures of labor market regulation through other regulatory schemes, I think there's just been a lot more pressure in this moment, that we're also facing a broader national conversation about persistent inequality, systemic racism, right? These, the ways in which our country has cemented a declining share of labor share of national income as compared to capital, that I think people are just really energized to find alternative regulatory solutions for.
All right, well, stay tuned because I think there's going to be more to come in this area. I think it's going to be a growing area of scholarship and perhaps a growing area of enforcement as well. The courts are going to get it right. So stay tuned, keep watching. We'll have you back and follow up on that for sure. But let me switch gears and ask you a very difficult question. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
Okay. Well, I maybe I gave it away a little bit when at the beginning of our podcast. So I got my PhD in comparative literature. So I wrote my dissertation on the rise of the novel and modern subjectivity in England and France in the 17th century. So anyone who wants to talk about Madame de Lafayette and Madame de Rambouillet and French salons in the 17th century, send me an email.
Have you been able to work that into any of your legal scholarship?
No, so I haven't. I think I'm interested in law and literature. I'm interested in reading about it. But as I was writing my dissertation, I actually started organizing with a graduate student union. And I think it really, it opened up my eyes to the struggles that workers in the service sector face more significantly. And it felt like a very pressing need to do everything I can to try to, fix what I think is a really, broken regulatory system for workers.
Let me ask you a different question, which is, can you give some advice to young lawyers interested in getting into and learning more about labor antitrust? How can they get into the field? What are the opportunities?
There are lots of opportunities. I would say in law school, definitely take antitrust law, but also take work law and labor law courses. There are opportunities for internships during your law school years in your 1L and 2L summer at the DOJ and the FTC that are also, engaging in labor antitrust cases. And don't forget the plaintiff's bar. There are a lot of private public interest law firms like Cohen Milstein, where I worked, but other law firms that are doing plaintiff side labor antitrust cases on behalf of, mixed martial artists, on behalf of nurses, on behalf of chicken processing workers. And so there are real opportunities to get involved in active litigation while you're a law student. After law school, there are increasingly more and more opportunities to practice in labor antitrust, not just at DOJ and the FTC or on the plaintiff's bar or on the defense side, but also at the state level. There's been increasing state attorneys general that are focusing on labor antitrust cases on behalf of workers, and really interesting developments even at the municipal level, like in Seattle. And at the state level, where states and cities are trying to be creative in regulating workers who are exempt from the labor law to establish protections for their organizing activity as against antitrust enforcement. So basically, exemptions, yeah.
All right, great. Well, let's go to our final segment called The Curious Hat.
And now it's time for The Curious Hat.
We are not all together today, but when we are all together in the studio, I have a hat. And in that hat are a series of questions, and we pull a question out of the hat, and then we ask you that question. Since we are not all together today, I have the questions in my hand, and I'm going to ask you to choose a number between 1 and 25, and I will read the question that corresponds with that number.
Oh my gosh, okay, 16.
Question number 16. Okay. Do you have any networking tips or particular ways you enjoy keeping in touch with those you've met during your career?
Oh my goodness. Well, we're in COVID land, so networking is very difficult these days for young attorneys and for law students. I would say, because you can't, go to people's offices or try to meet them at various events or conferences, that you shouldn't be shy about emailing. And you shouldn't be shy about having Zoom coffees with people either. People are all mostly working from home or working in isolated offices and feel very lonely. And so talking to a bright young mind about how creative they can be in thinking through potential labor antitrust cases is just a great break for people in their day. So I would just recommend, don't be shy, email people, be concrete and detailed about who you are, what your interests are, and why you chose them as someone that you would like to speak with to have an informational meeting or other kinds of career-based conversations. And, ask to have a Zoom coffee and be flexible about timing and really take initiative there.
What I found actually is that just remembering who your friends are.
Yes.
And just making sure once in a while you say, hey, let's just pause for a second and get back together. I mean, social friends and also work friends. I think even in COVID land, I think people just appreciate hearing from people, getting an update.
Yeah, absolutely. I know I do. And I think, a lot of law students don't realize they of course, you have friends within your class, but your entire class is going to be your permanent career network for the rest of your life. You should be proud of all of the work you've put into your law school career. And the pride that you take in all of that work is something that I think your classmates share and feel a certain identity with. And don't be shy.
I just wish there are so many people in my law school class who were so much more talented and smarter than I was. I just wish I realized who they were at the time so I could have kept in touch with them.
And it's always the quiet ones, right?
I know. I still have friends from law school, but unfortunately for me, I guessed wrong. I just went with the nice people. But in any event, let's close that out. Thank you, Professor, for joining us, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.